Hello, I'm attorney Paul Whalen with Afford Law. We practice criminal. Today we're going to discuss self-defense as a defense in a criminal case in Massachusetts. But before we get to that, I just want to explain a little bit about how we work at Afford Law. Afford Law is all legal representation for criminal and family law matters in Massachusetts at a reasonable price. That means that we use a sliding scale fee based on your income. So the less you make, the less we charge. Our whole reason for being is that we want to try to make ourselves as affordable as possible for the working men and women so that they can have a trained, experienced attorney in their corner when they're going into court on criminal or family law matters. The issues that are involved in these two areas of law are so complicated and the consequences are so great that we feel that everyone should be represented. Certainly, a lot of times cost is a problem for a lot of people. For people who don't make much money, they can get a public defender, a court-appointed attorney, or legal aid. If they make enough money, they can go on the open market and hire an attorney at the going rate. The problem is for most folks that I know anyway, they're caught in the middle. They're working people, they're working hard, but they don't have a lot of money to throw around. So to come up with a large chunk of money, because let's face it, most lawyers are expensive, it's very difficult and puts a great strain on their finances. So we do offer experienced legal help for you, possibly at a reduced rate. Please feel free to visit us at affordlaw.org for more information and to see if you qualify for. So self-defense. Self-defense is a defense. If you're charged with, particularly we see this in assault, you have the right to defend yourself physically from a physical attack. So if you are being attacked, or if a reasonable person in your position believes that they are about to be attacked physically by another person or persons, you have the right to defend physically. Now, having said that, that right is not universal. There are limitations on it, several limitations on it. Stand your ground state. Stand your ground basically means that even if you're not in your home, that you don't have to retreat. You don't have to go get out of the city. Stand your ground and defend yourself at that moment. That's in or outside of your home. That's not true in Massachusetts. In Massachusetts, you have a duty to retreat. That means that if you're outside your home and somebody is attacking you, you have the obligation before you commit to physically repelling that attack, you have the obligation to retreat if possible. In fact, you have the obligation to try to avoid that encounter through any means possible. So if it means running away, if it means calling for help, whatever it might be, a self-defense, a physical self-defense is the option that's available to you. If there's an opportunity for you to get out of the situation and you don't, and you engage, you are putting yourself at risk for being charged with an assault and battery and not being a self-defense defense. In addition to that, you cannot exceed the amount of violence that is being perpetrated upon you. So you can't be too overly aggressive in your response to that assault or the threatened assault. To me, that's a little ridiculous, because if somebody's coming at you, how are you supposed to be able to gauge what the proper level is and so forth? But it doesn't matter what my opinion in this regard, or in many regards. But so you can't exceed the reasonable bounds of a physical confrontation. You cannot be the aggressor. If it shows that you were the person that started the interaction, you cannot then claim a self-defense defense if you are charged with that. So if you start the fight and then you say, well, I'm just defending myself because the other guy was in the fight with me, that's not going to work. So those are some of the limitations of it. And another thing is you cannot use self-defense if you are retaliating, if the encounter has come to a conclusion and then you prolong it by engaging further in a physical altercation, in a fight. Just say somebody attacks you, you get into it a little bit, and then the fight is over, or they threaten you, but it never happens. But your emotions are high, and you go after that person. So the encounter is done, but now you're taking the fight to the other person. You cannot claim self-defense in that case, because as far as the law goes, the encounter ended, and any further by you in trying to engage in a physical fight with the other person cannot be forgiven, if you will, on the basis of self-defense. Now, I've been referencing that things outside of your home, because there is a very important distinction between any encounters that happen in your home and any physical encounters that happen outside your home. So if you are faced with a situation inside your where somebody is threatening you or is actually engaged in harming you physically, you do not have the obligation to retreat. You can stay there and defend yourself, because it is in your home. It's called the castle rule, or the castle doctrine. You know, what a person's home is their castle, so they don't need to retreat. They don't need to take any other action. If you're in my house causing me harm or threatening to cause harm, I have the right to repel you physically from that encounter. So those are some of the factors that go into a self-defense claim. Another technical issue is, if you're going to claim self-defense in a criminal case, you must put the Commonwealth, that is the prosecution, on notice yourself of that claim, so that they can be prepared for it. You can't bring it up only at the first time at the time of trial. But that's something for your lawyer to figure out. And hopefully you're not representing yourself on a criminal matter, certainly not at trial. So those are some thoughts as far as self-defense goes. It's very difficult sometimes to determine what is involved in a fight. Emotions are running high, and your reaction to those can be, it's very, very confusing time. So if you're acting in self-defense, make sure your attorney knows that. If you have any witnesses, obviously, that can say that the other person started the fight or whatever, that's going to be very important as well. But you do have the ability to defend yourself under certain circumstances with certain limitations. So at Afford Law, we would be happy to answer any questions that you have about self-defense or any other criminal or family law matters. Please feel free to visit us at affordlaw.org, not .com, but affordlaw.org. We have a lot of resources there, a lot of answers to your frequently asked questions. Please feel free to stop by, book a free consultation with us. We'd be happy to talk to you. We're doing virtual consultations at first. They are free. There's no obligation. So we'd be happy to try to answer any questions. If you'd like, you can submit questions to us, to me, at paul@affordlaw.org. I'd be happy to get back to you, and we can take these questions in these live streams as we go. So thank you very much for your time. I appreciate it. If you have any questions, give us a call or visit our website, affordlaw.org. At Afford Law, we're making justice affordable. Thank you.